court went a little bit anticlimactic today. It was a little anticlimactic for a lot of people, myself included, because I'm at the point now where I've been waiting for today for 3 months. I've been waiting for today for 3 months just because it was my first chance, just the first chance to start this fucking fight. The government gets to run your name through the mud. They get to lie. They get to misrepresent things, and they get to make, we'll word it more diplomatically. They get to make honest mistakes too. They get to make honest mistakes or just suspicious misrepresentations. That's what people don't understand about some of the stuff, like the mandated reports and stuff. It's like there are people who get things wrong with no negative intention at all. They just get something wrong. Like maybe a mandated reporter who didn't report a single thing firsthand, but maybe what they did was they took reports from 4 people who fucking lied. Maybe that's what happened. Not sure. That could hypothetically happen, but maybe 4 people got together and fucking lied. And a mandated reporter made a report with 0 firsthand knowledge. Maybe that happens. All right. The people receiving the report don't necessarily know that, right? Like they don't know that. So they may take it and work on it. The problem is when they find out that they got it wrong, when they find out that it was a fucking lie, they don't have any duty to correct it. They don't want to. They want you to be a villain, because otherwise they would look like maybe they did some shit that wasn't right. Even if you give them the benefit of the doubt, you just go, hey, kind of fucked up, you know? And they're content to just let that marinate. Maybe let a couple things, maybe just a couple things out into the public to make it look a certain way. Maybe those things just accidentally get out, like unredacted documents that I couldn't possibly have had yet and still don't, because all of my copies are redacted by statute, but the unredacted ones aren't. Maybe like they just let those slip out by mistake, right? And just let it sit there to maybe taint people's opinion of you or whatever their motivation is. I don't even know. Maybe that happens. But they do that, and you're forced to just sit there eating your fucking hand for 3 months, just waiting. Eventually, I'll get discovery. Eventually, I'll look at what they have. I know that this can't be right, but I got to see what they have first. And you just sit and sit and sit, and they don't give it to you, and they don't give it to you, and they finally give you bits and pieces and little things here and there. They do last minute dumps, less than 24 hours before a hearing. They do all that stuff, all that cute little interaction. And you have to just fucking take it, because the temptation is to fight. The temptation is to go out there and say, no, this isn't this is that. This isn't true. That's not true. You sit there and they just, okay. And they take notes. And then all those things you said, all the ways you defended yourself, everything you said when you didn't have the information, then they use that against you like a sledgehammer. And I thought that the practicing lawyers out there would know that, but they just didn't. Because why would they not? Maybe they're just a bunch of
white bread ass niggas, man.
Maybe that's what it is. Or maybe they saw an opportunity and their credibility was on a sacrificial altar for those little super berries, little super chats. I'm going to get my super chats too. You guys are fucking embarrassing. But it's fine. I'm sure you'll keep being right. It's okay. And look, I'm not saying I'm going to win straight out the gate here. I'm not saying how this case is going to go. I'm not making predictions. I'm just saying I have rights and I will assert them and I will fight this as long as I can possibly fucking fight it. Because I actually am fighting for something. Rather than sitting there cackling and malding about just to try and take people's money to give them the opinions they ask for. Hope it works well for you. But I've been waiting for this day because we got to finally start to fight. I get to finally speak because I can only really speak through my lawyer. The stuff I talk about here is either wildly public knowledge or has been dealt with in some way or is completely adjacent to any real issues. And so, you know, but we finally get to do some talking. And the first thing we did was filed this Frank's challenge. And the Frank's challenge says very simply, the detective, Officer Pomplin, lied. And the standard is, with knowledge of the falsity or reckless disregard for the truth, misrepresented to the judicial officer information that was material to the issuance of the warrant. That's what our filing says. To make a showing under Frank's, you have to make a prima facie showing. That means on the face of the challenge, you have to say which statements were false and give a statement of reasons why they were false. You have to list that if it was a misrepresentation that was material to the to a particular element, or if it was an intentional misrepresentation, whether or not it's material. If we win on this, we then get a Frank's hearing. And the Frank's hearing is where those statements, the challenge to those statements gets evaluated, right? You duke it out like old school. But if you heard any legal experts or practicing lawyers talking about suppressing evidence or motions in limine or anything about evidence in the case or trying to exclude anything out, and they're doing some sort of analysis about that, well, they're flat out fucking wrong. And they got the basic question of the purpose of the motion incorrect. So if that was the analysis from any of the legal experts that you guys have seen, I tend not to watch theirs because I've been so embarrassed to have known most of them that it's just not really worth actually engaging the content. But if that's what you've seen, I can tell you straight out, that's the first fucking filter. If that's what they're talking about and reading these motions, they've got it wrong from jump, and their analysis is going to be as garbage as their shows are. Kevin Brownell says, how does April's statements after the warrant was executed challenge the warrant getting signed in the first place? I don't know that they do. That was a separate issue, but you know, there you go. Well, as stated by my lawyer in court, let's do it this way. There is a time and a place to raise the challenge to Fifth and Sixth Amendment violations not on behalf of a third party that are impacting the defendant as a result of violations of a third party's rights. Okay. The question is, do you bring that challenge too late? Because there's case law suggesting that there is a waiver where if you don't raise that issue soon enough, it's waived because now it's too late. So we raised the issue in our motion, and the issue again has been resolved by concession from the county attorney. So that's good. The county attorney acknowledged that the rights were violated, and they're not going to use those statements. So there you go. Perfect. But what does it have to do with the warrant being signed? Nothing. It's a separate part of the challenge.